further hearing in the field, London Borough of Southwark in another, and Transport for London.
Well, Mr. Elvin, is there anything you want to add?
I have a few things. I reviewed what Mr. Morshead said orally yesterday, and there are a couple of points I just want to pull together. Can I just begin by saying, overnight, I've reviewed two things. One is the additional statutory provisions that I mentioned yesterday. That's been sent to the court electronically, and paper copies have been circulated. Can I just deal with those? The first item, I'm afraid they're not paginated because my ability to paginate PDFs is very limited overnight. But I have put large page numbers.
Have you not? Yes.
For the individual items in the contents. Section 36 of the 1980 Act is the first, which makes it clear that trunk roads are maintainable at public expense. You can read that from 36C. That was also in the 1959 Act, which is item 2 in the bundle, section 38 D of the 38(2)D of the 1959 Act. The other two statutory provisions are the Land Registration Act provisions I mentioned yesterday, sections 11 and 12, which make first registration of freehold and leasehold interests subject to overriding interests, and then Schedule 5, paragraph 5 of Schedule 1, which makes public rights overriding interests. Because the 2002 Act wasn't in force at the date of the transfer order, I've included as the final item the old Section 70 of the 1925 Act, which had public rights as Section 71A as an overriding interest there as well. So I hope that completes those matters I promised yesterday. I've also...
Are public rights defined in the 2002 Act?
I confess I was. If they're not, I've been misled by Emmett on title, which.
That can never happen.
Sorry about that. so it must be right.
Well, I assume it is.
If there's an issue, I can check it and send an email.
The other thing, you mentioned yesterday, I think, or someone mentioned a sort of developer entering into a Highways Act agreement to dedicate a road.
An adoption agreement under Section 38.
That's under which section?
Section 38 of the Highways Act 1980.
That's it. And when that happens, what does the road vest in the highway authority?
It's like dedication. It becomes a highway, and then Section 263 operates.
Yes, so you would say, does the top two splits in that case?
Yes.
And possibly Mr. Morshead would agree that in that case...
I think that would be common ground, wouldn't it?
Yeah, I think it probably would. Yeah. Okay.
The other item I produced this morning is the note that I promised, my Lord.
Yes, thank you.
On Section 266A. It also includes, for what it's worth, my theory on as to why Article 2.1a appears in the order, but not in Section 266A at the end. It may have been because the reverter provisions for trunk roads only apply to councils that are highway authorities, and TfL isn't a council within the definition of the Highways Act. It's no more. It's what Mr. Morshead characterises luxury submissions. It's really not relevant to your consideration, but I thought I'd include it since Mr.
Well, as he's got a deluxe
well, I thought you could have
submission. You can have one too. Yes.
Thank you very much. That's very helpful. I haven't yet sort of got to grips with it, but I will appreciate
that. Maybe we'll all try and get to grips with it.
Maybe.
Fine. The groups of points I want to deal with begin with Mr. Morshead's emphasis on Section 328 yesterday in oral submissions. The court will recall his reference to where the context otherwise requires. Just a series of points to make about that. Firstly, it can't be a reference to the general meaning of highway because there is no general meaning of highway given by the Act. It must refer to the whole or part or to the ferry or waterway part, which then appears after where the context otherwise requires. Secondly, in my submission, the context demonstrates that Parliament is using highway in the physical sense as well as in the right-of-way sense. And can I give a couple of examples of that? In 265, 2651A, highway must mean something other than the public right-of-way, because the public right-of-way doesn't vest in the highway authority. It's a right exercisable by the public. And what it refers to as highways insofar as immediately before the operative date were vested in the former highway authority. And my submission is that is clearly an indication to highway, at least including highway as a physical right, that is to say, the right identified in cover date. Secondly, you get a similar context from the distinction between highway, land and property in Article 2 of the Order. Article 1 refers to highway, vested in the former highway authority. Article 1b rather, refers to property in sub-article 3. Article 2.3 then refers to property both as land and then as intangible property, rights and liabilities. And in my submission, therefore, as elsewhere in the Act, and I'll give you two more examples in a moment, Parliament is using highway in contradistinction to land and property. So if Parliament intended all of the land on which the highway is situated to vest in the new highway authority, it would have been very simple to do so. And indeed, that language appears in another section, which is section 256, which is in Bundle 2, tab 11 of the authorities, memory stick pages 1509 to 1511. And that relates specifically to the power to exchange land to adjust highway boundaries. And there Parliament uses the phrase land on which the highway is situated in 256. And so within the same Act, certainly is able to and does designate the entirety of the land by that phrase. And indeed in subsection 4, this may be verging on the deluxe submission again, but in subsection 4, if the highway authority doesn't have all of the land on which the highway is situated, then it can still transfer it and pay compensation to the landowner. That's subsection 4b.
Sorry, can I just catch up with that? It was MS page
1509 to 1511. The final example is section 330, 1576 to 1577 of the memory stick. And that relates to the construction of certain enactments relating to the execution of works by statutory undertakers. And there the phrase is used in subsection 1 on page 1576, enactments empowering undertakers to execute works under, in, upon, over, or along, or across a highway, which again suggests it's being used not simply in the sense of the intangible public right, but also in terms of the interest in the Highways Authority. The second point I've already dealt with by giving you section 36 of the Highways Act. Mr. Morshead's big clue relation to section 265, that there's no reference to highway maintainable at public expense. My short submission is trunk roads under 265 are maintainable at public expense. But you have to go to section 36, the provisions I gave you first thing. My third point relates to the airspace point, in particular raised by Lord Carnwath yesterday. As I've already submitted, that's a matter that can go under 2.1b. Just remind the court that even in the case of the title to land in the ordinary sense, where airspace used to be said to be usque cholum. Of course, as the court will know, that's subject, following cases such as Baron Bernstein and Skyways, to a principle of what the ordinary usages are. And so airspace, even in the case of an ordinary title, has an indefinite limitation. And it perhaps isn't surprising that highways airspace is similarly indefinite. But if, as my Lord Carnwood said yesterday, does that not make matters unclear for a developer? Well, the same would apply in the case of any highway where a developer wishes to develop over a highway, of having to ascertain what is essentially a flexible interest. And of course, the position under land registration and the provisions I showed the court a few moments ago is equally unclear, because even with registered land, the highway's interest is an overriding interest, and so one doesn't get a definite answer even by searching the register of title. And finally, of course, in the case of a highway authority wishing to deal with a developer, one critical feature that it will always have to bear in mind, if it's a highway vested in the Baird sense, is of course that highway is inalienable, because section 263 requires that the highway in the Baird sense is vested in the highway authority. There's no power to alienate that. If a local authority wishes to remove highway status, it must stop it up.
Well, it has to go to court to do that, doesn't it? Or does it no longer? Used to have to.
Absolutely right, my lady. There are procedures under in the magistrates' court for stopping up. There are also procedures under the planning legislation as well.
So it's inalienable for as long as it's a highway?
For as long as it's a highway. So the issue that a developer may be faced with a situation of uncertainty will arise, we submit, in any event. And finally, on this point, my submission is that in reality it is far less of a problem, and is a common problem, in comparison with the effect of TfL's case, which says that what transfers is the interest of the highway authority, and the problem that gives rise to layers beneath the property, layers beneath the ordinary use zone. And we say that is far more of a practical problem created by the TfL approach to construction than the airspace issue, for the reasons I've submitted.
Can I just...
of course, my Lord.
I mean, I was glancing at the evidence of Marcus Main in particular, for example. Is he your officer?
Yes, the Southwark witness.
Yeah. And I wondered whether I'd been misled into thinking that what this is all about commercial use of airspace, that actually it looks as if the real problem is much more mundane. It's a sort of sheer patchwork of interests that you get, and indeed laterally as well as...
Which is why I said that, I did point that out yesterday,
yes.
my Lord. It is airspace in part, particularly in the city.
But I was looking at volume 2A, page 412 not in the volume, which gives one a picture of Elephant and Castle.
Elephant and Castle is a particularly contentious...
Well, because you've got most of the road is unregistered, but then you've got all these bits and pieces.
And it's being redeveloped at the moment.
Yes. But is that the real... I mean, obviously there are commercial aspects to this, but there are very practical aspects.
There are which is why the evidence was put before the arbitrator. I gave you one example yesterday. Yes. The evidence was put before the arbitrator to show there are real practical issues which arise from this.
But I mean,
it isn't simply airspace.
And the trouble is, whichever we choose of your two alternative submissions, it's not going to solve all those problems by any manner of means, is it?
Well, my point in relation to it was that the problem is complex, whichever construction the court adopts,
Yes.
and that it's not a reason. It drove, if you look at the arbitrator's decision, and you've been referred to the paragraphs, and I'm sure the court has read it, the arbitrator's decision was driven by the consequences, because he begins with 2 pages as to consequences. In my submission, there are difficult consequences from either approach. And in my submission, it is not a reason for reaching a conclusion as to one construction or another. One has to approach it as best one can. with reference to the patchwork of statutory provisions and authorities, which is why we say it's important to note that no court has departed from the Baird principle when looking at the question of what vests in a highway for over a century. And that level of certainty is, we submit, as the Court of Appeal found, an important fact. Can I then finally, to turn to defend the Court of Appeal, at least in some small respect, I made my submission yesterday that my case turns on what vests in the Highway Authority. My learned friend criticised the Court of Appeal at length for using the word highway. Might I just, out of deference to Lord Justice David Richards, say this? It is clear from Lord Justice Richards' judgment of paragraphs 22 to 33 that he understood perfectly well that the issue was what vests in a highway authority and was using the term highway in that context. He runs through the authorities that the court has been taken to and has, the Baird line of cases, and it is quite clear that the Court of Appeal understood what the issue was and that it was an issue of vesting. And indeed, if one even goes to Mr. Justice Mann's judgment at paragraph 39, core bundle page 176, he talks about the vesting of the highway, what he calls the road bits, and then the functional land. But even he uses highway in the sense of not merely the public right of way. And in my respectful submission, a fair reading of the Court of Appeal's case, although it is not essential to my submissions, as I said yesterday, is that the Court of Appeal well understood the position and examined the 19th century authorities to see whether what vested in a highway authority as highway, which is the language used of Article 2.1a, was in fact the wide proposition advanced by TfL or the narrower Baird-based proposition which we advanced. And in my respectful submission, Mr. Morshead is wrong to castigate the Court of Appeal to the extent that he does, but I say that in deference to the Court of Appeal, but it doesn't matter to my submissions for the reasons I have already advanced. My lady, those are my submissions in completion of my case. Unless there are any further matters, I can assist.
Lord Briggs has something he wants to ask.
Mr. Wilson,
Yes.
Mr. Elman, can I just pick up your... I think you concede that airspace can, depending on the facts, pass under 265(1)(b),
Yes.
or the equivalent of that in the order. Can I just try an example on you to see how that concession works in practice?
Of course we will.
Suppose the old authority acquires land for highway purposes, but by conveyance, either on a compulsory purchase or a voluntary purchase, and sometimes they merge into each other.
Indeed.
The day after and it gets the whole vertical plane as a result of that conveyance.
In the traditional sense.
In the traditional sense.
Yes.
What does it hold any part of that vertical plane otherwise than for highway purposes?
It may depend on whether anything has been built over it in the meantime.
Well, I'm just asking you, I'm taking this in a series of quite carefully graded stages. The day after the conveyance, it's acquired this for the purpose, still virgin territory, nothing's been built on it by way of roads or anything else.
Well, it's not simply a question of whether it's acquired for highway purposes. It's a question under B as to whether it's required for the functioning of the highway as such, effectively.
Well, for the purposes of their functions in relation to the highway.
It will do certainly so far as the zone of user is concerned. There may be a basis for saying it should go wider because one of the reasons for which it was acquired was in order to allow future expansion, future improvements, which might include changes in the vertical alignment of the highway, may include allowing different vehicles on the highway, may include the inclusion of some highway infrastructure which requires further height. But it will be a question of fact in each case.
If it then builds a road, and let's suppose the zone of ordinary use is up 30 feet and down 6 feet for that particular road at that particular time, does it follow in your submission then that everything in the vertical plane outside that zone isn't held for the purposes of their functions in relation to the highway?
There must be a degree of flexibility retained to allow the flexible change in the zone of user, I suspect.
Well, let's go up 1,500 feet.
I'm happy to concede that there comes a point when it will not, because it becomes, it can't be reasonably expected that it all becomes part of the functional highway, say, at 1,000 feet. But in my respectful submission, there might be some doubt as to whether that fell within what the courts permit as airspace available to the title holder in any event post-Bernstein.
Going up and down, there's a sort of grey area outside the then zone of ordinary use. That might still be held, using the words of B, for the purposes of their functions in relation to the highway. So how does one know that the date of either trunking or dedication is a GLA road? What passes if it's something less than the whole vertical plane?
That is the difficulty of any dedication of a public highway in any event. There is always the area of uncertainty. It's what I was saying in response to my Lord Reid yesterday, that I didn't accept Malone and Friend's submission that it crystallises at the date of designation of the GLA road, and that some account must be given to the fact that it is able to fluctuate because it's that peculiar type of interest which is permitted to fluctuate by law. And so what passes must incorporate the ability to do that to some degree, and that would be a matter for the function test under B, if not as part of the zone of ordinary user under A. But I readily concede that there is a grey area, but I would also submit, as I have, that there's a grey area in any event. A, with regard to highways up and down the country, which are in the same position as London highways. B, that position exists with regard to freehold title in any event. There's no unlimited airspace conveyed with the freehold. The courts have grappled with it in a number of cases over the years, including the Bernstein case, and there's no clear line to be drawn in terms of traditional freehold title either. So it is simply a complex problem which exists, and it's reflected in highways law as well.
But how does the arbitrator give effect to that then? I mean, he's got to decide what property passes.
Both vertically and laterally.
Yeah.
Yes, well, he's got to make a decision on the facts. He will have to make a judgment.
Yes, I know, but are you saying that his judgment will say, well, what passes is this area subject to a grey area at the top? He can do that?
Yes, I suppose if you think about the history of a long-standing road, it will have been a highway in the days when you could rent out the grazings on the highway.
Yes, indeed.
And then once tar macadam was invented and you had a metalled surface, the necessary foundations for that would mean going down further into the ground than you previously had done. And then once you start having large lorries, for example, on roads, you have to have deeper foundations. And so the extent to which the vertical, to the extent of a highway in the vertical plane historically will have changed from time, developed over time.
Well, Lord, that's why I say it's a problem which applies to highways throughout the country, because that problem is inherent both in ancient roads and roads which are newly dedicated if the whole of the title hasn't been transferred to the highway authority. If one dedicates or enters into an adoption agreement, you're necessarily imposing the zone of ordinary use on that land. And it's a common ground between us that would be a 263 case, and therefore Baird would apply to it. So it's a common problem, but it's inherent in the law of highways.
Yes. I suppose, does it help at all to think of it as an interest, which is defined by reference to ordinary use, rather than as it were, a title to an identifiable block of soil or stratum of air?
Yes. And that, I suspect, is why the courts defined it the way they did, and the land registration process deals with it not as a title as such, unless, of course, the there's been an acquisition or a compulsory purchase or whatever, and the whole of the title has transferred. I suspect that's why the land registration solution is to record it as an overriding interest, so that there is that lack of definition, and one has to rely on the general law in order to answer it. But it's not a problem which is peculiar to this situation.
But it's common ground that in B, property has its ordinary meaning as the land, the vertical plane. I mean,
yes, it would be ordinary. So
the suggestion seems to be that under A, there's a sort of sui generis interest, which is different from property in its ordinary sense.
Well, it's property in the sense that it's been described in Coverdale and in Runcorn by Lord Evershed and in Rolls. It's a terminable interest, and it's an interest without precise boundaries, but it is a species of property.
But it's different in that sense from B, which you accept as property in the ordinary Megarian-Wade sense.
B is property defined as land or intangible property in 3, yes. And there's that clear distinction, and the distinction in the other provisions I took the court to earlier this morning. If that answers my Lord's question, those are my submissions.
Thank you very much indeed, Mr. Elvin. Thank you. Yeah. Mr. Mills? Ms. Morgan.
My lady, let me start with that last point while it's fresh in everybody's mind. We got there by the route of section 328, my learned friend's submissions about the meaning of highway. And based on that, one of his propositions was that the Act uses the word highway to describe something physical as well as a legal interest. I've never suggested otherwise, I recognise that. But he went on to say that that was in contradistinction with land and property. Now, with that, I do most strongly disagree. We're concerned with section 265 specifically, whereas I showed you, and you've been actually shown no analysis of section 265 at all by Mr. Elvin, but I showed you that the word highway is recognised as part of the genus property. And property is itself specifically identified in that section as including land. Specifically. It is an impossible contention to suggest that the word highway has some meaning which can be, let alone should be, separated from land in section 265. The internal drafting of section 265 is enough to make that contention unarguable. My learned friend referred to the idea, which is true, that public rights, including the public right of way, are an overriding interest. That's of course true. That doesn't stop the Highways Authority, which owns either the top 2 spits or the land generally on which the highway is situated, from registering substantively its title to that land. We must not lose sight of that point. The property interest recognised in Runcorn, I think it's the Runcorn case, the Lord Evershed's judgment, is a property interest recognised by the Law of Property Act. So I think it's important to have cleared those points out of the way at the outset. I also need to say something about what was said about section 256 in volume 1 of the Authorities Bundle. My note says the memory stick is 1509.
It is.
And what my learned friend said about this section, if your ladyship remembers, is that when Parliament means to refer to the land on which the highway is situated, it knows how to do it. It spells it out. Well, there are a number of points that can be made about this section when one reflects on it. The first is the obvious one, that it has a completely different provenance, actually, from both Section 263 and Section 265. And the second point, flowing from that, is if you reflect on it, it doesn't recognise the Baird principle even in relation to land that the Highways Authority only owns the top 2 spits in relation to. It assumes that even where, does your ladyship see, the Highways Authority, for any highway maintainable at the public expense, doesn't say, assuming that it owns more than the top 2 spits, any highway authority owning a highway, the highway authority of any highway maintainable at the public expense may, for the stated purpose, enter into an agreement with the owner of any land which adjoins or lies near to the highway, providing for the exchange of any such land for land on which the highway is situated. This seems to be saying that even in a case where, if you applied the Baird principle, the Highways Authority only has the top 2 spits, nevertheless it can convey the whole interest in the land on which the highway is situated. What this section reveals, my lady, I'm sorry if I may do so, speak bluntly, it's that the Act is not consistent in its treatment of the word highway. The difficult concept that the Baird approach has given rise to has not filtered its way through fully into all parts of the Act. It hasn't been recognised. Properly interpreted, Section 256 is a further reason against taking an extended view of this Baird approach. And there may well be other examples, which brings me to my last point on this section.
You said that came from somewhere else. Where does this
I'll have to go into that, but
Well,
my point is it's not part of the particulars of provisions that originated in the vesting that we looked at yesterday, and it's certainly not part, I believe, of the trunk rate.
Yes, I mean, what you're saying is really it's assuming you're dealing with the land in its ordinary sense, and certainly insofar as you're getting land from the neighbouring owner, that's what it will be.
It must mean that.
Whether you, and it's applying whether or not what you actually have is the 2 spits or something more than that.
Yes.
Does 256 4B recognise and deal with the Baird problem?
I'd better look at it.
Page 1510.
B.
You have to start at 4.
Yes, I see.
A and B are alternatives. A is what you might call a non-Baird situation, I think. B might be a Baird situation.
A is non-Baird.
And because there the land belongs to the highway authority. That's the land on which the highway is situated.
Yes.
But B contemplates that the land might not belong to the highway authority.
I've done an injustice to the draftsman. If you go to subsection 4, my lord, your lord is right. It has been dealt with in this way. That doesn't negate the point I've made. That the draftsman is recognising that this word highway is not what conveys the Baird principle. It's not a function of any vesting provision generally. You have in every case to ask, what is the interest of the Highways Authority? So subject to my lord, thank you, my lord, but subject to that point, the submissions I've just made about 256 are intact. And but my final point about...
How does B work?
Well,
if your land doesn't belong to the highway authority, it will convey it. And it vests the land in the transferee for an estate in fee simple.
It does seem to be saying... It does seem to be saying that even when the authority under the top 2 spits rule doesn't own more than the top 2 spits, tough.
It looks as
tough on whoever owns
on
the
whoever actually does own the top 2 spits. So it's really... One could almost put it this way. It's a nod at the Baird principle. It's not adopting it as core to the principle of what is a highway or should be treated as the highway. It acknowledges that the Baird principle, if anything, is a bit of a blip. But, my lady, may I come to the final point I want to make about section 256, which I respectfully say is really the way through this point. It's the point made by my Lord Justice Carnwath in that Mitchell case. It's not productive to conduct this kind of compare and contrast exercise in an act like this, expecting that every single provision will hang together as a comprehensive whole. The tapestry is too rich for that. And 256 shows us it's an example of the stopping point. The next point I wanted to make, arising from matters touched on this morning, is to address the Court briefly on what my Lord Carnwath raised with Mr. Elvin about the complicated roundabout diagram shown, I think, at Elephant and Castle. And the question is about what is the real point at issue between the parties. And I'm no better really informed about what underlies commercially the issue between the parties than I was yesterday. It may be that it includes lateral matters as well as vertical matters. But we have been able, I submit, my lady, to isolate a point of law for this court which doesn't actually depend on the commercial implications. It can't be viewed separately from them. I accept that.
It's not so much the commercial. I mean, I think it's practical implications.
Exactly.
And anyway, there we are. We've got to deal with it.
Yes, but I accept that the practical implications are important guides to interpretation. The controlling principle we say applies, and I may come back to this, but let me emphasise it at the outset, is not that section 265 should be read as a panacea. It's not taking away problems that the old Highways Authority had under the common law. But it is making sure that the new Highways Authority is not in any worse position. It's in the same position, with all the complications and advantages that the old one had. It would be far too ambitious for me to say that 265 is intended as a panacea. That's never been part of my case. Lady, I then wanted brief. I'm not going to take time on this, but I do think it's important in this case to examine how far we have come in the arguments. If you remember how it was put by my learned friend certainly in the written argument, if you go back to that in the core volume at 113. The first summary proposition, which is later developed, is about the word highway. That has not been pursued at all. It's not suggested that the word highway has a common law meaning which imports on its own the Baird concept anymore. Subparagraph 2 is not maintained. If you see the second sentence, in both instances, Parliament has used the term highway to import the general common law meaning. That's not maintained. And in the fourth paragraph, we find also this paragraph does survive, my lady, but it does two things. It deals with my deluxe point. But the other thing it does is provide an addition. If you go back to paragraph 3, it's an additional gloss on what's said in subparagraph 3. So where we've ended up is that the whole argument depends not on the word highway, but on an analogy between section 263 and 265. Now, that is not a small change in the council's case. But one can see why they're driven to it. And the problem they face is that the logical premise, the necessary premise of that argument, certainly the one on which it has been constructed by the Court of Appeal, is this idea that highway in and of itself has the general common law meaning that has been described. So I do ask you to recognise that. It brings me to another point that is important, really important. I showed you that part of Mr. Mayle's reasoning which analysed the effect of the words insofar as vested. I showed you his reasoning which explained that those words are redundant on the council's interpretation. And you've had no answer to that. So what my learned friend is asking you to do is to say that paragraph A has only been inserted as a precaution anyway, and so you don't need to consider what is the meaning of those words. But if you reject that, if you think that paragraph A does some work, we haven't heard from Mr. Elvin how it can be given a meaning other than the one explained by Mr. Mayle. That is why I said it is an important point. Now, when we turn to consider the Council's arguments more generally, I'm going to ask you to be alert to two factors which I suggest are they crop up repeatedly in his arguments, and they undermine almost the whole response. The first of them is that he has taken it for granted that the Baird concept should be understood as applying widely, and so widely that anyone wanting to depart from it would have said so expressly. I'll remind you how particularly that came across in his analysis of the Reading Committee report. That is the error of assuming the thing that needs to be proved. The second flaw is that in more than one respect, his answers don't address section 265. They depend on factors that are specific to the transfer order. And you'll remember that it's agreed, and I didn't understand him to be departing from this agreement, that this matter relates equally to section 265. That's paragraph 41 of the Statement of Facts and Issues. So quite a lot of the argument you've heard doesn't go far enough. Because even if you accepted that it was an explanation of the transfer order, the explanations offered wouldn't engage with section 265. Now, my lady, we saw the first of those flaws most acutely in the submissions about the Reading Committee report. And you recall Mr. Elvin saying, well, the committee didn't say anything when it was talking about the trunking principles, trunking provisions, to show an intention to depart from the top two Spitz principle. He said the silence is what was important. But it's a classic example of assuming what needs to be proved. If you assume that it would have been obvious to the committee that the top two Spitz principle needed to be explained away, then his submission makes sense. But I showed you parts of the committee's report which make clear that the opposite is the case. The committee understood correctly this key point. The trigger for the top two Spitz rule is the vesting of an interest in land for the first time in the Highways Authority as a result only of the authority's duty to repair. That says nothing about the amount of land which should vest in other situations, such as where the trigger is not the duty to repair, but that one authority is being swapped for another. Now, to treat those two situations as the same, or even as analogous, I say, with respect, is simply misconceived. And the reason why it didn't occur to the committee that it needed to say anything about this is that it didn't occur to them that anyone might muddle the two situations up. And that is apart from the fact that the committee also went to the trouble, as I showed you, of recognising explicitly that the word highway needs to be seen as embracing a number of different possibilities. It is quite clear, it is pellucid, my lady, that the committee proceeded on the assumption that they were not importing the Baird principle into what is now 265. Now, Mr. Elvin pointed out that a trunk road is maintainable as a highway at the public expense. Well, of course it is. I never suggested otherwise. But so what? That's not the relevant question. The question is, what triggers the vesting? Under Section 263, it is that fact which is the trigger. Under 265, it is a different fact which is the trigger. There is no logical or other connection between the two. Now, I say the fact that the authorities have the same or similar functions, or it may be true as a fact, it's not the trigger, and at the risk of repeating myself, my lady, there is no hint in the reasoning in any authority or in the Reading Committee to suggest that the top two splits rule can be triggered by a swapping situation rather than the one engaged by Section 263. And on that last point, my lady, I do need to refer to two statutory provisions in case it's said that I've ignored them. The first, and I think my Lord Briggs was conscious of this point, the first is Section 29 of the 1929 Act, because this is the section that turned local roads into county roads, or some local roads into county roads. And there was a suggestion that this was analogous to the trunking of a road. You've got one highways authority being swapped for another. And I can see the analogy. But I ask my lady to recall how differently it was achieved. The text is in tab 7 of volume 1. This is memory stick 1324. Subsection 2, I think, is the operative bit.
In section 29?
Yes, my lord, yes.
Section 29 of the 29 Act.
Exactly, my lady. Mm. This is what was later looked at in Runcorn, Tithe Commission, Runcorn, okay, I think. I'm not going to read it out. My lady sees in subsection 2 particularly that the model which has been adopted is very closely the old 19th century form. If anything, this point makes my own argument for me. You've only got to compare it with Section 265 and recall the features that I listed under Section 265 about its language. I do submit that any suggestion that Section 265 can be taken as having the same meaning or effect as Section 29, it's not statutory interpretation. That would just be wishful thinking. You cannot treat these two things as saying the same thing.
What about Section 7 of the 1936 Act?
I'm coming on to that. But before I leave Section 29, may I just, to complete this point, remind the Court of the one case which considers it, that's Tithe Redemption Commission, Runcorn, Volume 2, Tab 24, Memory Stick 1872. I'm going to invite you to look briefly at the argument, just to remind you. I've given you a bad reference, I think. 24. Tab 24, MS 1872.
Sorry, is it page 1872?
My lord, yes. That's where.
Oh, yes, where it starts, yes.
Yes.
Yeah.
That's just to locate it, but the bit that is important to draw to your attention is that at page 1877, you see in the argument of Mr. Russell, Queen's Counsel, and Robert McGarry, as he then was, their argument had nothing to do with the issue which concerns us. Their argument assumed, well, Section 29 does the same thing as we're familiar with under the Baird principle. They were making a completely different point. They were saying, when you look at the kind of property interest that the Baird principle creates, it doesn't qualify under the Law of Property Act 1925. That was the issue between the parties. So the Court of Appeal, in that case, proceeded on the assumed basis that Section 29 had the Baird meaning. You can't even find in this authority support for the proposition that Section 29 has the Baird effect. One can see that it is more likely to than Section 265, but it would be wrong to read this authority as saying that is its effect. That was its assumed effect for the purposes of considering this issue. Milady, my next point is going to be about Section 7 of the 1936 Act. Now, the overall submission is that it's unproductive to try to align Section 265 with Section 7 for reasons which are similar to the ones I've given under Section 29, but there's an additional twist. My first point is that no court has ever construed Section 7, so far as I know. The second point is that Section 7 was reformed when the opportunity arose in 1959. Now, by itself, this makes clear that some different effect was either intended or might have been intended. It would certainly have been within the scope of the committee's remit to have removed any doubt about what Section 7 achieved. Critically, in order to make it work consistently with its professed original purpose. Because you'll recall that there was a ministerial statement back in 1936 about the purpose of the 1936 provision. We put it in our case. Referred to it in paragraph 25 at memory stick page 80, and we've quoted it in the annex at page 99. It might be better to go to the annex, page 99, than the body of the case. If one takes it up from 98, my lady, 1936 Act was administrative. Object to transfer the administration of principal roads to central government, emphasised by the Minister at the second reading of the Trunk Roads Bill. We set out the various extracts that we could find that were relevant. Paragraph 16 is important. The basis for the transfer, said the Minister, is that the Minister should take over the road and all properties and liabilities attaching to it. And then at 17, at the Bill's second reading in the Lords, the Earl of Erne described its objectives in similar terms. The Bill, which now reaches your Lordship's House after having passed through all its stages in another place, confers no powers on the Minister of Transport, different from those which the highways authorities already possess in relation to these roads. The opportunity has not been taken to effect any alteration in the highway law generally. The government agree, and many of your lordships must feel from your own experience that in numerous respects the law requires amendment and consolidation, and it is the Minister's hope that in the not too distant future consolidation may be effected. The principle on which the bill is based is to make a clean transfer of responsibility from the beginning of the next financial year. Clean transfer of responsibility. Now, looking at Section 7, and my Lord Briggs identified the difference between the structure which it adopts and the structure adopted in Section 265. It is perfectly understandable that a committee looking at this may well have wanted to clarify how it operated to ensure that effect was given to the principle of a clean transfer. Now, my Lord, the Reading Committee in 1959 didn't give details about its thinking in making the changes which it did make to Section 7. But of course, it had received the draft bill from a draftsman in the Department of Transport. So it isn't one of those reports where you would expect commentary on every single provision or every single change. The emphasis would have been on those points which had been drawn to the committee's attention in the consultation process, rather than on points which hadn't attracted attention or which seemed obvious. So one shouldn't read too much into the fact that the Reading Committee didn't say anything much about the changes which it was making to Section 7. And I say, what is important is to recognise there was no presumption that Section 7 had the bad effect. You can't infer that from any material.
It is your submission that Section 7 had the same meaning as you now ask us to give.
I say it's uncertain. I accept if you study Section 36, it's easier to find clues that make it look like 263 than 265, because the opening words speak of property vested in the Highways Authority for the purposes of their functions in relation to the highway. So it's easier to get that clue. You still have to work out later on, working through the structure, well, which branch of its provisions are all the strips in the highway being treated as belonging to. It's basically an unclear provision. It is a much less clear piece of drafting. So I'm not actually making a submission about it, a distinct submission about its meaning. I'm saying its meaning is unclear. And we don't have to grapple with it because we do now have the clear legislation which emerged as a result of the exercise in 1959. The relevant principle, my Lord, on this question of whether you should go back to the 1936 Act, I suggest, is the one described by Lord Hoffman in the Goods case. I think the passage I showed your Lordship. The other bit, on this point, because there has now been a Consolidation Act in relation to this particular provision, I say that the earlier bit that he discussed is applicable. Lord Wilberforce's dictum in Farrell and Alexander, self-contained statutes, whether consolidating previous law or so doing with amendments, should be interpreted, if reasonably possible, without recourse to antecedents, and that the recourse should only be had when there is a real or substantial difficulty or ambiguity which classical methods of construction cannot resolve. That is the principle to which there is the limited exception of which goods itself is an
But
example.
in any event, you say you should only look at the previous statute if it helps you, and if it doesn't help you, then you don't.
Yes, exactly. All you do, if you go back to Section 7, is raise another difficult interpretation question. It's not going to help you, and Lord Wilberforce's approach is a statement of the law, I suggest, which should stop you from doing so. I can't really say that there's any statement that can stop this court from doing it, but I hope your ladyship understands the point.
I'll just test that by reference to two examples. Firstly, the one I put to Mr. Elvin, where the Highway Authority, for the purpose of building a road, acquires land by conveyance and therefore gets the whole vertical plane. Do you say that once it's built the road 5 feet down and, let's say, space 30 feet up, the rest of the vertical plane doesn't cease to be vested for the purposes of their functions in relation to the road?
Lord, I've been reflecting on the suggestion you made yesterday that one way of cutting through this is to treat paragraph A as if what it applies to is the land vested in the Highways Authority qua Highways Authority.
Yes.
And
that's the as such abbreviation.
Yeah. I was
Which
going
you could say is there in Section 7 across the board.
Good. I was going to come to this towards the end of my submissions, but I'm happy to deal with it now. I recognise its importance as a point. But if I may do so, I'll do it in the context of the broader submission I wanted to make. So I'll do it in this way, by confronting this sort of bump in the road that has occurred as the result of the concession I made below about the shooting galleries and other slices that might exist as separate identifiable points in the vertical plane. How does Section 265, this is my heading for it, how does Section 265 deal with tricky cases? Now, we were shown some tricky cases by Mr. Elvin with those photographs which show complicated built structures situated above the usable area of the highway. There's also the known example of these shooting galleries. That sort of approach does a very good job of conjuring up an impression of complexity, and it stimulates one to try to avoid a construction which would transfer a school or part of a shooting range or anything like that. That's one's obvious instinct. It's a very beguiling method. And I may slightly have succumbed to its temptations in the concession I made. But when one stands back from it, one does have to, I suggest, recognise that the meaning of Section 265 shouldn't be viewed through the prism of the most complex situation which could arise. Or at least not only and not mainly through that prism. One needs to reflect, I suggest, on the likely paradigm case which the draftsman assumed. And that's not what is shown in the photos. The likely paradigm, he's dealing with trunk roads, is a stretch of road in the middle of nowhere.
Yes, I mean, we know that, but we've still got to deal with the difficult cases.
I am coming to that. But it's an important point to make, my lord, because the question, did the draftsman make provision for tricky situations, arises even in the middle of nowhere. But the fact that the paradigm case is so simple may help to explain why he adopted one solution rather than another. He might have adopted an elaborate solution if the problem had been perceived as being likely to be an elaborate problem, such as has in fact arisen in London. But if in fact he was making a different assumption about the sort of problem that might arise, he might make different provision. And the provision, we say, he made, is in subsection 5. For these tricky cases, the solution is agreement. This legislation goes back to 1959. It may be that the the expectations then are no longer current, perhaps I'm being over-romantic, but at that time there was perhaps a greater expectation than now of cooperation between public bodies. They're both public bodies. Why should the draftsman have assumed or legislated on the assumption that this would be difficult to agree? And in fact, it isn't difficult to agree. TfL isn't suggesting that it wants a part of St Paul's Girls' School or that it wants the shooting gap.
I think it's the boys' school.
Is it,
It's the City of London school.
well, I'm not sure. I've got a son at the City of London school. Right. There aren't any highways underneath it. I think it's the girls' school. Yeah.
Yes.
So
It's in the Barbican.
But I mean, there's got to be a legal solution. I mean, obviously, it's by design, we wouldn't be here if everyone had been able to agree. So what do you say is the answer in law to the school?
the answer in law is that the city corporation needs to ask for a retransfer. In fact, it won't get any objection from us. But if
why is it transferred at all? It's not held by anyone for the highway purposes.
I'm coming on to the other way of looking at it in a moment. But if it got an unreasonable answer from us, we would be open to judicial review.
Yes, we know that. But I mean, I'm not sure it's that unusual. I mean, I'm looking at your lovely sketches. It shows the last one, MS 110. Shows a sewer running under the road.
Yeah.
Now, there must be all over the country sewers, ordinary sewers running under roads, which are where the sewer is held for public health sewerage purposes, not necessarily associated with the road.
Yes.
And, I mean, are you saying that the sewer passes, or I'd have thought that's just separate?
Well, if the sewer may not be owned by the Highways Authority, in which case it won't pass, of course.
Well, it's on your view that the highway is... you have all the land under the highway, but there's a sewer.
No.
What's the problem with saying the sewer is held by another authority for different purposes? It doesn't pass.
If the sewer is owned by the Highways Authority, then presumptively, yes. It may be owned by someone else, in which case, of course, no, it won't pass. And that's an important insight. And this is what brings me to the other way of looking at it, which is going to be my alternative.
I mean, that's dealt with by Lord Briggs as such.
That's what I'm coming to.
All right. Good.
The difficulty I have about that example is that the sewer, if it were owned by the highway authority, but not for the purposes of its highway functions, obviously, it wouldn't have passed under the 1936 Act. And we know that the 59 Act was a consolidating statute. And the 1980 Act, 265, is in the same terms as Section 228 of the 1959.
The 1959 Act is not a consolidating act. It's consolidating and amending.
Oh, well, yes. But there's no indication that Section 228 was meant to have a different effect from...
Neither is there any... Well, I'm repeating what I've said about Section 36. One cannot draw a clear view about the intended effect of Section 36, I suggest, and one needn't do so when one has the clear wording of Section 265. But let me move on, because I don't want to...
Bear in mind, the Reading Committee's report is the report of a committee on consolidation of highway law.
I showed your Lordship the terms of reference, which make specific reference to the invitation to make amendments within...
But I don't understand why you're making such a point of this. I mean, you don't want the sewers.
No, Lord, I'm only making I don't wish to create the impression that I'm making a big point of it, because I'm moving on now to my Lord Briggs's point, which is the other possible way of looking at it, which may well be the right one. But I do want to flag up that there are two possible solutions in order that I can show you, the court, that there isn't a third one. The other solution is to... It builds on this fact, my Lord, that the transfer order and Section 265 are only dealing with the property of the Highways Authority. They're not dealing with third-party interests. And that triggers this chain of thought. If a public body can hold land in different capacities. If it appropriates land held in one capacity to another capacity, then the situation legally is at least analogous to the situation where it's transferred it to another person. It's not the same, obviously, but it's analogous to that. And perhaps that's the right way of looking at it, and it supports my Lord Briggs's suggestion. If at the relevant date in 2000 there had been an express appropriation of land in the route of the highway, or, I'm not saying that's the only way, there might have been some factual development on the ground from which appropriation can be inferred. And in that situation, there may be cases where land in the route of the highway and vested in the highway authority should in truth be treated the same way as if it were vested in someone else. But this situation is subtly but importantly different from applying the test of functions under paragraph B. It doesn't depend on a broad-ranging inquiry under which the incoming authority has the burden of showing that land is held for a highways function. The fact that the land is situated on the route of the highway and vested in the highways authority raises a presumption that it will pass under paragraph A to the incoming authority. The burden in this situation is on the outgoing authority to show that at the relevant date it had already appropriated the land to some other use. That's the difference. And so
Can I try yet another example, which I can see how that analysis may work in relation to schools and shooting galleries and sewers and public laboratories, where they're all continued to be held by the same authority, but wearing its school, shooting gallery, public laboratory or sewage hat. But what about where land was originally acquired, let's say by the Corporation of London, which probably has wider or a larger number of hats than most local authorities, for the purpose of building a new school, and it was acquired by conveyance, so it got the whole vertical plane under the conveyance.
a new school?
Yeah, for building a new school. But before any new school was built, a road is then built over part of that land and to be used as a public highway. No need for vesting under 263 because the authority already owns it. And then the road becomes a GLA road, still when no school has been built. What's the consequence of the land having originally been acquired, save for the bit where a road is built, on the rest of the vertical plane, not for highway purposes, but for some other purposes?
It may be that in that situation, my lord, the concept of appropriation still applies. You ask, well, what is the land that the Highways Authority appropriated to highways use? And in that situation, it had land held for the purpose of a school. The question is, how much did it appropriate as a highway? Which is analogous to the question under 263. But in that situation, the distinctive feature is the original purpose for which the land was acquired. It was impressed at the outset with some different purpose, which later enables the authority to say, we held it under a distinctly different capacity, so we should be treated as if we were two owners.
Why do you say the burden of proof lies one way rather than the other?
Well, I suggest that this is because of what I've called the presumptive effect of land being situated in the route of the highway. If I say what paragraph A is doing is it's distinguishing between land in the route of the highway, that's A, and land lateral to the highway, that's B. If you find land in the route of the highway and it's vested in the Highways Authority, then the presumption, at least under A, is that the whole interest of the Highways Authority in that land will vest in the new authority. The effect of the qua Highways Authority point that my Lord Briggs's suggestion implies is to give the outgoing authority the chance to say, no, we have already appropriated it to some other use, or no, it was originally acquired for some other use and we have only appropriated part of it to this highways use. You get it from the structure of the act. That's where the difference in burden comes from. And I know it sounds like a narrow point to have reached at the end of a long argument, but we've heard how complicated and difficult this particular arbitration is going to be. The burden of proof on a point like this may be absolutely critical.
The odd thing is that the true paradigm case may be that the outgoing authority originally acquired an ownership interest in the land under Section 263. It's only in cases of conveyance, whether compulsory or voluntary, I think, that a different outcome would arise. Do you agree, for example, that on dedication, it only works because 263 steps in and provides for the vesting?
We've always accepted that. Yeah. That's a complication that the current Highways Authority has to deal with.
That's the true paradigm. And the exception is the case of compulsory or voluntary purchase. But why does the burden start with an assumption that the whole vertical plane is...
Oh, sorry, I misunderstood in suggesting that the paradigm was a case where...
Yeah, well, you were relying on the paradigm concept to get round the tricky cases.
I'm not sure that I accept that the paradigm case can be taken as being that highway has been dedicated in that way. In fact, if memory serves, I better just check this, but it might get an indication the other way around when you come to reflect on the committee's report in 1959. I'm going to struggle to find this. Volume 3. Tab 33. I think it was part of the passage. Yes, Your Lordship, if you go back to 2175, this is volume 3, tab 33, memory stick 2175. Where the committee was reflecting on what became what is now 265. It's a great pity you don't get anything much clearer, but you do.
Sorry, are we saying 2175?
2175.
Yeah, thank you.
2175, please.
Yeah.
This isn't the predecessor of 265, is it? That's clause 227 on the next page, I think.
Sorry. 225 is dealing with what became... I've given you the wrong number. 225 is dealing with what became 266, which... Yes, is what became 263. Sorry, became 263. And the only point I wanted to draw to your attention, which cropped into my memory in answering my Lord's question, is the bit that begins no express provision. No express provision is made for the vesting of highways not being trunk roads constructed by the minister, though perhaps this is unnecessary, since the minister must acquire land on which to construct a new highway. Now, I mustn't overread this, but I do suggest it rather suggests that the approach, when one reads later into the trunking and detrunking provisions, the approach of the draftsman must have been influenced by that thought. you can't make a general assumption about the origin of the highway in question when the subject matter is trunking and detrunking. So I'm sorry if I misunderstood my Lord's original question. I don't accept that, that Section 265 takes as its paradigm case in any meaningful way a highway consisting only of the top two spits originally.
Yes, because the minister, nothing will have vested in him by common law or under Section 263, so they would have to have been an acquisition.
Yeah.
Relevant to detrunking.
It is, but it works both. Section 265 works both ways. And obviously the committee was aware of that. My Lord, so the court has a choice, and I'm not sure how to rank these choices, but the choice is between regarding the only relevant control as the power to agree to a retransfer, or the alternative, which seems increasingly attractive, my Lord Briggs's approach, giving effect to the concept of appropriation. But the third option is clearly not available. The third option put forward is clearly not available. Treating Section 265, paragraph A, as if it has nothing to do. It has no work to do.
The arbitrator, I think, dealt with the possibility of appropriation in paragraph 178 and 179.
He dealt with it in the context of paragraph B.
Yeah, and he referred to a couple of decisions of my own about inferred appropriation and so on. But I don't think we need to look at that, do we?
I don't think so. I'm not departing from the analysis that he's put forward there. It may be that it can be read also into paragraph A. I'm not saying there is some particular formality that's needed to give evidence of appropriation. Does that answer my Lord's question about the hypotheticals? Then let me retrace where I think I'd finished my submissions about Section 6 of the 1936 Act. Yes, my next submission relates to my learned friend's argument about the verb transfer as distinct from vest. And his main answer to his main explanation for the choice of the verb transfer in the order was, well, this can be explained by the specific provisions of Section 408 in the Greater London Authority Act. This was the specific power under which the transfer order was made. Now, just as my headline point, of course, that's got nothing to do with Section 265. But let's dwell on it a little further. Because I'm going to say that when you place Section 408 in its context, it reveals yet further indications against my learned friend's interpretation. He correctly said that Section 408 gives the Secretary of State power to make an order transferring property or creating a new interest, or both. So that distinction of Mr. Justice Stanley Burnton was not repudiated, but it was said, well, there are special factors which mean it doesn't apply to the transfer order when you look at the enabling power, even if it would apply to Section 265. Well, the initial point to make is that one still has to ask, which power did the Secretary of State use when he made the order? The fact that he could have created new interests doesn't absolve one from the need to interpret the order to find out whether that's what he did. But there is a much more profound difficulty facing Mr. Elvin, which I now need to explain. We need to start by putting Section 408 back in its context. You'll remember that the transfer order was preceded by a designation order. The designation order identified the roads in London which were going to become GLA roads. There was no legal obligation on the Secretary of State to make any transfer order at all. He could have stopped with the designation order. If he had done that, TfL would have acquired the top 2 spits because of Section 263. That's common ground. But the Secretary of State chose to exercise his powers in 408 in addition. And Mr. Mayle was right to draw attention to this in paragraph 115 to 117. He recognised he was dealing with a property transfer order. Now, there is no suggestion that the transfer order was ultra vires section 408. This is a crucial point because Mr. Elvin said, well, TfL's function was no wider than the outgoing councils. That would be relevant if we were debating the vires of the order, but we're not. Taking it as intra-vires, the submissions made by Mr. Elvin about the nature of TfL's functions doesn't go anywhere. And we have to remember that the Secretary of State was initiating a brand new scheme. TfL has wide powers under the 1999 Act, including the commercial use of land. It needed to start with something. And it was up to the Secretary of State to decide what it would start with. The answer to the question, what was TfL to start with, is answered by looking not at the designation order, which on its own would have given the top 2 spits. You look at the property transfer order. Now, the Secretary of State had wider powers than the Mayor. That's not surprising. Otherwise, the Mayor could bootstrap and expand his own empire. The Mayor doesn't have the Section 408 powers either, which tells you that you don't learn anything from Section 266 capital A either. He's got different powers. His powers relate to a scheme that has been set up, not to a scheme that is being set up. And we can now turn to Section 408 and see its influence on the transfer order in its proper context. If we go back to the 1999 Act, I'm going to lose it, it's in paragraph in volume 2, I think. At page 1, memory stick 1634,
Mr. Morshead, I didn't make a note of when Mr. Elvin sat down.
I'm conscious of the passage of time.
2 minutes to 11. Well, you're over time, Mr. Morshead.
I apologise.
So if you wouldn't mind swiftly wrapping up your remarks.
I will do, I will, as much as I possibly can. 408, 1, Minister of the Crown may by order make provision for or in connection with the transfer. That's the verb used. Mr. Elvin drew attention to subsection 7, but that provides that an order under subsection 1 above may make provision for or in connection with the grant or creation of an estate or interest in or right over any land or other property, and the grant or creation of any other rights. That's not the same as saying that if you make an order for transfer, that will include an order for the grant or creation of any other rights. It's doing something quite different. It's drawing attention to the difference between the two concepts. It's not saying that an order for transfer will be read also as an order for the creation of other rights. It's saying the opposite. It's saying you can also make an order for the creation of new rights. That's why separate power is conferred to create new interests. So actually, Section 408 works in completely the opposite direction from what Mr. Elvin suggested. It recognises an express distinction between transfer and create, and this is important because any draftsman acting under Section 14A of the 1980 Act and 408 of the 1999 Act needed to be careful not to use the word transfer if he meant to create new interests. So the choice of Section 265 as a model was emphatically unsuitable if the intention was to create these new floating freeholds. Lady, that nearly finished brings me back to what Mr. Elvin said about the effect of paragraph A in the article in section 2651 that we're concerned with. I submitted that his interpretation left that provision without any meaning. And now that we've been through the analysis again, that submission is good. It hasn't actually been deflected. His attempt to deflect it involved that journey through section 408, which is specific to the transfer order, and which doesn't work anyway. Suggestion that there was some doubt which needed to be resolved by the presence of paragraph A is also, I suggest, extremely convoluted. It's actually rather difficult to follow. I think the final point is, maybe 2 points, is about acceleration. We've largely covered this, my Lord, but in response to my Lord Carnwath's points. But, my Lady, Mr. Elvin at one point seemed to be saying that he didn't expect the arbitrator to have to adjudicate on the extent of the vertical column, but I didn't detect any consistency to his submissions on this. First, he said there was no need for the arbitrator to take a decision, but he later accepted that there might need to be a CPO in relation to parts of the column of land, and he also accepted that the arbitrator might be asked to adjudicate upon its extent. And I say it's clearly intrinsic in his approach that the arbitrator will be invited to rule on the vertical extent, even in relation to those cases where we say land passes underneath paragraph A. So we say that one can't dodge the bullet on Mr. Elvin's approach. The arbitrator is being asked a question, and the question is how he's going to have to answer it. I think I do have other points, but I take in mind my lady's point.
Well, as long as you've made the main points that you wanted to urge upon us.
I've made the remaining point I have is it relates to what Mr. Elvin said about the problem. He said it would be problematic. The exclusions which apply in paragraph B don't also apply in A. But that's not right, because if you look at the exclusions, they cannot apply along the route of the highway. That's the only point.
Can I ask you just to clarify one thing on where we go in terms of an order? I mean, if we dismiss the appeal, then we simply confirm what the Court of Appeal said, presumably. If we allow the appeal, are we going back to the arbitrator's very complicated award at page 126 on, or do we leave that for further submissions?
I'm going to take the coward's way out and say that it depends on what the court decides as a matter of substance in view of the submissions. Because it may be that the relief won't be as simple as restoring the arbitrator's award, depending on the view this court takes about the correct view of the law.
Well, so you're effectively saying we should seek further submissions on what the implications of our decision are for the form of the award.
Well, in every case, or only depending...
If you dismiss the appeal, that won't be necessary,
Oh, of course.
so far as I can tell.
Yeah.
If you are with me on... Actually, no, I think probably in every case. I think probably in every case.
Just looking at it, I think there
Yes.
will be aspects of it which may need clarification.
Can I agree with Mr. Moore's-head on that? Because if the court takes a different view, even though agreeing with the thrust of the Court of Appeal's judgment, it may require tinkering, and it would be better to have submissions when we've seen the judgments of the court. Would the court forgive me one point of clarification? It was in relation to something that Lord Carnwath asked in relation to the issue of the paradigm case that my Lord Briggs raised. It's simply the point that not all trunk roads were newly created, and just to remind Lord Carnwath that under section 3.1 and 7.1 of the Trunk Roads Act, they were transferred from existing highway authorities when they were initially designated. Yes. So the paradigm case may well apply to at least the first tranche of trunk roads under the Act. I do apologise, but...
But of course, quite a lot of them were going through nowhere. They've been going through nowhere for a very long time.
But not in London.
Well,
thank you.
You have presented us with an absolutely fascinating conundrum. We have really enjoyed the last day and a bit. We're grateful to everybody, both their oral submissions and, of course, to those who have no doubt worked hard on the written submissions, but have not had the opportunity of speaking to them. We will now go away and try and work out what the answer is and let you know in the usual fashion. Court is now adjourned.